It's not possible. I didn't say it would be easy, Neo.
So Miss Chelsea knows I see her present. I see Mr. Jeremy knows present. I see Miss Penich present as well. So everyone is here. This is contempt matter. Ms. Penich, you may proceed.
Thank you, Your Honor. I have a brief opening. We're here, and I would say that my paralegal, Rachel Newbill, is on, and she will be handling the exhibits. So if she can be invited to share the screen when it's time.
Ms. Marshall, if you'll give Ms. Newbill opportunity to give her the ability to share.
Yes, ma'am.
Thank you, Judge. Okay. Judge, why are we here? In a pattern that we've seen throughout the history of this case, Jeremy Knowles only does what and when Jeremy Knowles wants to do. Doesn't matter what the sanctions are. If he doesn't want to comply, he simply won't. This court previously held him in contempt of its temporary orders. I believe there were 5 grounds of contempt the court found his prior testimony unreliable, inconsistent, and self-serving. So it's no surprise we're back here. Today, we find that Jeremy paid none of his financial obligations as ordered per the final judgment, not child support, not attorney's fees, and not cooperating with the property. He is still trying to get back to be assumed by Ms. Knowles as ordered by the court. We tried to resolve all these contempt issues by asking.
Say none of them?
None of them as ordered. There are sometimes he paid very late, but he's still very behind. I mean, that was essentially one thing he paid, which was in arrears, and that was late. We tried to resolve this without court intervention by asking, because he delayed issues related to the assumption that she could assume the marital estate, assume the mortgage for the marital residence. We asked for an extension because it was 120 days and he had delayed producing some documents, which caused a delay in the assumption process. And we offered to reduce the amount of equity owed to him in the marital estate by the amount he has failed to pay. So he wouldn't have to come out of pocket. He was fine with reducing the equity, but he was not okay with extending the assumption. So my client, at great significant legal fees by bringing us involved, was able to hasten the assumption process, had a closing date for the last day, and Mr. Knowles didn't show up. So don't forget, the mortgage was in his name. He had to show up in order to sign it over. He's also removed the child from the state without following the court order. We needed to file an emergency motion for the conveyance of the house so that she didn't lose the ability to assume the mortgage at the lower interest rate. It's ready for the assumption. He needs to sign the document so she can calculate what equity he is still owed and pay him. She can't do that without having the house in her name so she can then get either a second mortgage or at least know what she owes him. So we have that issue. And this wasn't on our notice, but Judge, we filed a 9/15/14 motion in February. It has gone unresponded to. We believe it's right to be ruled on.
Okay. Mr. Knowles. Unmute.
Yep, I'm here. Thank you for hearing us today. In regards to Ms. Panich's claims of Chelsea not being able to assume the mortgage, she was approved to assume the mortgage on 2 days before the 120th day set by the court. The mortgage or the house has 2 mortgages on it. The first one she was approved to assume. The second one is non-assumable. As Ms. Panich stated, everything is solely in my name when it comes to the mortgage, but Chelsea does own the property. Her name is on the title and deed. It is not on the mortgage. She does not need the mortgage to get a second mortgage on the house. She is the co-owner of the property. So at closing, she could have the second mortgage queued up to pay off the balloon payment and also pay my equity at closing.
Mr. Knowles, why were you not at closing? Let's just get straight there, okay?
Because the conditions of the order were not met.
And what condition was that?
That my name be removed from all aspects of the property.
Well, how can she do that if you don't go to the closing?
She does that in advance of the closing. All the documents queued
Who
up.
would do that, Mr. Knowles?
The
Like,
mortgage
that doesn't make-
company.
that doesn't make sense.
The mortgage company. She would get approved to assume the second mortgage.
You think she's going to remove your name off the documents prior to the closing,
No, this has all happened at closing
but you were not at closing?
because all the documents were not prepared.
Oh, so the closing attorney canceled it because the documents were not prepared?
No, she cannot assume the second mortgage, and this is by HUD's regulation. So the second mortgage has to be paid off in full at closing. She was
But you
not.
didn't attend the closing.
Huh? Sorry? So the second mortgage has to be paid in full at closing. To do that, Chelsea would need to take out a second mortgage solely in her name to remove my name from the mortgage. This all happens concurrently, all at the same time. I sign this document, it pays off this loan, she gets the house, I get the equity, the remaining balance, all at the same time. Because the second mortgage on the property is non-assumable. If she were to assume the first mortgage and pay my equity and remove my name, I would still own wholly the second mortgage and not the property. And that cannot happen based off of HUD's regulations, not mine.
So HUD told you not to go to the closing.
The documents were not prepared to remove my name from the second mortgage at closing.
Okay.
Your Honor, just to be clear, there is no second mortgage. There is a balloon. And my client cannot resolve that without her name also being on it. And that would only happen through the assumption.
Her name cannot be on the balloon payment. It is non-assumable. It has to be paid off at closing in full. It is a non-assumable loan. Ms. Spinach is speaking incorrectly. I have all the documents and exhibits from ISN. They're all serviced by Mr. Cooper.
Okay. Ms. Page, call your first witness.
Your Honor, I call Chelsea Knowles.
All right. Ms. Knowles, raise your right hand. Do you solemnly swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth, so help you God? You're mute.
I do, Your Honor.
All right. All right. You may proceed, Ms. Panich.
Thank you. I'm just going to cut straight to this, what you just heard. Can you clarify what's the difference between the first and second mortgage and what you were prepared to do?
Yes. So I was fully approved for the loan through Mr. Cooper, who currently services the loan. And I was told by Mr. Cooper that they only handle the assumption. The balloon payment Jeremy is referring to, not related. We even had that in an email. And even Mr. Cooper stopped responding to Jeremy because he continuously would email them over and over and over about matters that don't involve Mr. Cooper. I went through the process, Judge. I went through the income verification, the credit process, provided documentation showing that I've been paying the mortgage for 2 years out of my bank account. I always paid the mortgage when we were together out of my bank account, so it was very easy to produce documents because I continued to do so, even when I wasn't living at the property. So I only had to produce 6 months of me paying the mortgage. I was fully approved based off of my income and my credit, and I was able to assume the loan with the same interest rate. The mortgage company pulled up the quitclaim deed. The quitclaim deed is literally already ready, just needs to be signed. I told Jeremy this. We even talked about equity. We provided him with an equity payout calculator. We even tried to resolve this before coming to court and wasting time. We made an offer. He came back with some ridiculous calculations. I'm not even sure what they mean, but long story short, I was fully approved for the loan. Mr. Cooper is aware of the balloon and still said it wasn't an issue. They still approved me for the loan and told
Okay,
me.
so the balloon, what was the loan? What's owed on the house?
The principal left is, I think, $302,000.
Okay, 302,000. And does that 302,000 include the balloon?
No,
Okay, what's the balloon amount?
the balloon amount is $50,000.
Okay, so what happens to the 50,000?
So once I actually own the property, then I can go to the balloon servicer. The balloon does not have to be resolved until the property is actually sold. That was the terms of the agreement. So what the balloon is, it's a COVID relief payment that
It's
we
a COVID relief payment that, yeah.
Right.
Okay,
and so we
when
don't
the
have
house is sold, you have
then
to pay
we have to pay it. It has nothing to do with this process.
Right. Okay. So it was the COVID relief money. So that, yeah. Okay. So when you sell the house, that 50,000, it will attach. Okay.
Yeah.
But I think Mr. Knowles' position is that the 50,000 has his name attached to it. Okay.
And he's right.
All
Because
right.
it's also attached to the mortgage.
Right.
But until I own the mortgage, then I can go to them and say, hey, this is now my debt.
Okay.
They won't even talk to me because I'm not on the mortgage. Like I had to get authorization from even Mr. Cooper, even though I'm on the deed, they wouldn't even send me any paperwork because I wasn't on the mortgage.
Right. Right. Okay. So I get it now. All right. So the $302,000 you got approved for, and you said Mr. Cooper, is that a company or the
Yes,
name of the company is Mr. Cooper?
Yes, Your Honor. That's the loan servicing company.
It's called Mr. Cooper. But who are you actually talking to?
The representative I'm working with, her name is Madison Duval, but she works for Mr. Cooper, who is serviced by Lakeview Loans. But that's the name of the actual mortgage company, Mr. Cooper. That's where I make the payments to.
Got it. All right. So you got approved. Their position is that that balloon that's attached to the house based on value to the house would remain. And obviously you would be responsible for on the sale. But since Mr. Knowles is attached to it as well, he has some concerns that he would still be attached to the balloon of the house, like a debt. He would still have a debt attached to the house. And he wants to clear himself of that. And your position is that the process is that once you have the home, then you can go to the company that has the note and place that note in your name because you have now assumed the house.
Yes, ma'am. And once I have the actual quitclaim deed to show that I actually own the property, then I will be able to go through the process of getting that note put into my name. And I just want to remind Jeremy that $25,000 of that balloon payment, we offered to deduct that from, actually, it's already been ordered that should be deducted from the final judgment. It was ordered that $25,000, half of that balloon payment, be deducted from the equity as well. That's in the final judgment.
I'm sorry, say that one more time. That's $25,000.
So half of the balloon payment, the final judgment reads that half of the balloon payment has to be deducted from the equity before, like as a part of his payout.
So that when you do sell it and that $50,000 is attached, his half would come because that's a debt.
Yes, ma'am.
Got it. Okay. And that $50,000 debt consideration is a part of the order already?
Yes, ma'am.
Okay. So essentially the court has dealt with that debt.
Yes, ma'am.
Yes, Judge. It's if the court wants to look at the final order, it's page 512.
Page 5 of the order.
It's number 2. I can if Rachel can put it on the screen if the court wants.
Okay, yeah, you can put it on the screen. That'll keep me from toggling screens.
Here it is.
Okay. 50%, personal mortgage. It's subtracted. 50% of the cost. Mhm. Okay.
Essentially, Judge, what we're asking is that you want the order that transfers her the house so he doesn't have to participate in this process.
Okay. So my concern about doing that, though, is that this is a final, and I don't know if I can make that large of a change. I can make changes that get to make sure we give the effect of it. So, for example, I can make him go to the closing and sign at the closing. That is what I can do, but I don't want to change the actual award because he's not behaving. Because there's a manner to get him to do what the order is intimating for him, or telling him, or intimating for him to do, which is basically to use the powers of the court for him to do that. But I understand your ask. Can I the $50,000 in covert relief? That one is also purely in just Jeremy's name.
Yes, Your Honor.
Okay, that one, huh? Okay. And do you happen to have that document where it explains that upon the sale, that's what you'll owe? Like, do you have that the note or the document that you signed regarding the $50,000?
Jeremy would have that.
Or from Cooper, is there any email from Cooper explaining how that $50,000 would occur? Like suggestions from them that the $50,000 would be handled, that you could handle that after the closing?
The email that I have from Mr. Cooper is basically my representative saying she's been fully approved for this loan. We only deal with the assumption. They're not really concerned with the balloon payment because the property's not being sold. I'm just assuming the loan.
You're assuming.
Mm-hmm.
Right. And okay, got it. All right then. Thank you. So let me go back to Mr. Knowles real quick. Mr. Knowles, you do recognize, and I think you have already indicated that you're not selling the property to her. This is an assumption, right? You understand that? So there isn't a sale. Do you understand that?
Yes.
Right. And this is generally just from my background understanding from other matters that I've handled related to these COVID balloon payments, that they normally attach to a sale. So a sale isn't happening.
So,
Like that's the debt you would owe upon the sale of the house, which I understand could happen at any point in time, and you don't want to be financially responsible for it. But by the same token, usually hopefully when you sell the house, you'll take that $50,000 note into consideration. But
So
I'm trying to get an understanding of what your concerns might be.
I totally understand. So allowing her to assume the mortgage, to remove my name from the title and deed, but still carry a bag, and the debt is actually $62,000, and still carry the debt of $62,000 and don't own the property or any rights to a property. So I owe money on something I don't own. I just want the full balloon payment paid off at closing. Like into your order.
Do you have the documents dealing with this $50,000, $62,000?
Yes.
You have it?
Yes. So I got it when she almost finished the process. I got a letter from ISN about the balloon payment specifically, saying that it doesn't have to be paid off, but if I were to keep the house, I don't have to pay it off. But if she assumes the mortgage, then she has to pay it off at closing. So Mr. Cooper is calling the process closing, with transferring of the quitclaim deed, the ownership of the property, and removing my name from the deed and title and paying me out my equity at closing. But still, I would own $62,000 of debt, which can't happen according to HUD. Like, this has to be paid off if my name is no longer on the primary.
So according to HUD, if this can't happen, because Cooper is saying it's happening. So if it happens with Cooper, what is HUD going to arrest you? I mean, what penalties are you concerned about? Because other than it being a debt, which the court has already considered and indicated this is how this debt is going to be handled, what concern are you concerned about? What penalty are you worried about?
That I would,
because the court has already indicated how the debt is going to be handled. So what penalty, what are you worried about?
owning a bag of debt, but having no claim to a property, and my future financial situation be affected because I have $62,000 of debt.
Okay. Can you send that? Can you send that document to me?
Yes, I will. Also, I want to.
You can send it to, do you have Ms. Marshall's email address? You can send it to her. Make sure Ms. Pennant is copied on it.
Yeah. I'm going to take a drink of water. Hold
on. Okay.
Also, with regards to the equity calculation of the payments, the appraisal was completed the day of closing. So on the 118th day of the 120 days, the court gave Ms. Knowles to complete the appraisal to calculate the equity. It was completed 2 days before the deadline that the court established.
I'm sorry, say that again?
Chelsea didn't get the appraisal for the house until the 118th day, or the day of closing. And the court gave me 10 days after she got the first appraisal to get a second appraisal. She allowed those two windows to overlap. So she was approved to assume the mortgage, but she wasn't able to remove my name per the order from all aspects of the home. And also she got the appraisal 2 days before the 120 days.
Well, you're using the word all aspects of the home. That's not what the order says. The order says is to assume the mortgage, and this is how we're handling the balloon debt. They're not the same. It all aspects of the home is not what I wrote. I said the mortgage, and that the debt will be handled in this manner. The debt that's attached to the house will be handled in this manner. So I've already handled those issues. The only reason I am giving some time to this issue is because I'm concerned about your position on maybe a financial penalty that could be assessed against you, or some type of criminal issue that could come up as a result of dealing with the government. And I'm trying to ensure that that's not the issue. As far as the debt is concerned and how it's going to be handled, I've already dealt with that. That's a done deal. I'm kind of making sure that there is no other penalty that could be assessed as a result of this transaction that the court was not aware of. That's all I'm trying to do. Because I think the debt, the court has already signed it, and I already said mortgage and the balloon debt. This is how it's going to be handled. That's that. So I'm trying to make sure that there's no other penalties that are going to be assessed or some other danger related to how the process is working, that some other result or consequence, that's a better word, the court has not considered that could affect you. That's what I'm trying to figure out.
Yeah. Okay. So the question is, the closing, since it's assumption of the mortgage and removing of my name from the title and deed, how is it different than a traditional sale of the property?
It's not a sale. It's an assumption. That's the reason why it says assumption, because it's not a sale. You're just assuming the debt. So she's not selling it. She's assuming it.
Okay. And so she has her name already on the title and deed?
I'm not sure, because I thought the closing didn't go through.
No, she already had her name on title and deed before the assumption. The assumption process is just to remove my name from everything. She already
The
owns
assumption process removes your name from the mortgage, the debt.
Mhm. Yeah, she owns the home already. She's on the deed and title as a co-owner of the property.
All right. What's your question?
So handling this all concurrently versus congruently, did I read the order incorrectly? Like the 120 days to pay the petitioner and laid out the rules of how it all works. Did I read that incorrectly?
I'm not really certain about what point you're putting out. So let me pull it up real quick, because I don't understand what distinctions that you're making. Because I guess I'm stuck on the fact that you can't do anything if you don't close. So let me go there. Now, well, is it on the screen? Okay. Tell me, what are you looking at that causes, what page do you want her to go to?
The top of the page 5. I think it's the top of
page 5. Okay.
Yeah. So respondent shall have 120 days to assume or refinance the mortgage and pay petitioner 50% of the net equity in the marital as resident.
Okay.
So long as the respondent assumes or refinances the mortgage, the net equity in the marital resident shall be determined as. So to assume or refinance the mortgage and pay the petitioner 50%. Like that should be done at closing, correct?
Your Honor, may I?
Okay.
I think he's trying to go behind the order, and I also think he could have filed for contempt if he didn't get the payment on the 120th day, and he didn't. He tried to stop the entire process, so it was impossible for my client to pay him on that day. On top of which, Judge, we were trying to negotiate.
Oh, what you're saying is you were thinking that your money was supposed to come to you on the 120th day.
No. the equity calculation, the payout, I understand that the money comes later, but everything be clean and final at closing. Complete. Like things to happen concurrently versus congruently.
Okay. What is it that you're saying that caused a problem from that happening in the way that you perceived it to be happening, that you perceived it to happen?
Okay. So has 120 days to assume the mortgage. There's 2 mortgages on the property. She's able to assume the first one.
The second one is not a mortgage.
So
It's a debt. It's a balloon note.
So it's serviced by Mr. Cooper also, but there's no payments required.
Huh? Yeah, there's no payment required until you sell it.
Yeah. Yes. But it's also serviced by the same mortgage company, Mr. Cooper.
Okay. So let's not deal with those particulars right now. Tell me what's in the order that was not that did not happen. Because I've already indicated how I see that. To me, the fact that I already calculated that as debt, to me means I consider that to be debt. So we've already resolved that. What's the thing that did not happen?
So I guess that's my misunderstanding. So my name does not have to be removed from all aspects and debt related to the property. It
does not say all aspects. But go ahead.
So my name doesn't have to be removed from the second mortgage or the balloon payment.
It appears that when this issue came up, paragraph 2 is how the court handled it, which is that there's a COVID relief payment. That's a debt. So that's how it would be handled. But go ahead. We'll figure this out. Tell me what happened.
Like my name.
I get that part. We've already dealt with that. What did not happen?
Oh, she also didn't have the funds to pay me.
Funds to pay you what?
Or assume the property. Her lawyer, Miss Victoria, she sent me an email the day of closing saying that Chelsea cannot meet the order as written.
Stating that what now?
She could not meet the order as written.
No, Judge.
Not meet the order as written, i.e. they can't take out monies for this or that. Yeah, yes, I get that. They may not be able to give you what's in the order. They may have to give you. Yeah, I get that because you're doing an assumption. So instead of a refinance. But anyway, go ahead.
Yeah. So she was able to refinance because she owns the property. A portion of the mortgage.
Say that again.
She was able to refinance a portion of the mortgage. That balloon payment, she's able to refinance solely in her name. She cannot assume that portion of the debt.
I don't think you can refinance that balloon note in your name. Are you sure that you can do that?
Yes.
Okay, let me show me where you're looking at that.
Okay. I'm looking for that document now so I can send it to Ms. Marshall.
Because it doesn't feel like you can refinance that note because it's a debt. And I don't know how you I don't even know how that would. I don't know how you would refinance it. You're saying you want to roll it into the note?
No. She could assume the first note and then refinance the second note solely in her name to remove my name from all aspects of the property.
Okay. Show me how is that done?
Yeah. She would take out a second mortgage on the property in her name only. In that closing, the balloon payment would be paid off in full, and she would own the equivalent amount of debt
Yeah, I understand your logical run through in your mind, but that's just a run through. What legally can you do with that note? Because this is a note that's created by the government during COVID. And so the idea that it is connected to the house and that there is a lien connected to the note, I don't know if all of those things are in place that what you can do with it. So if your position is it can be done, I want you to show me how it can be done. Because to me, it's an odd thing because it's just a note and it never comes due if you don't sell your house. So I don't know how you refinance it if it never comes due, or it comes due only upon the sale of the house.
Sorry. So it does come due in 30 years.
In 30 years. Okay. In 30 years, it comes due.
Yes. It comes
Okay.
due in full, like in 30 years or at closing when you sell the house. If the name on the deed and title change.
Right.
So
can you show me where you can refinance it? Can you show that to me?
Yes. So I connected Chelsea also with a different, as Chelsea stated, the person she was working with only works in the assumption department.
Uh-huh.
So I work with a separate person in the like refinance or mortgage department.
Okay.
So Chelsea with that person, both parties on the phone, like to walk her through. Like, and Miss Spinach wrote in her note that, I wanted Chelsea to refinance. I wanted Chelsea to refinance a certain portion, only this portion. And the way you do that.
I'm sorry, say that again.
So I wanted Chelsea to refinance the $62,000. That's it. And the way you would do that is you would take out a second mortgage only in Chelsea's name. Because her name is on the deed and title, she can take out a mortgage as long as I sign.
But if when she does that, she'll be making payments on a second that this balloon or attachment doesn't require. So that's not the same. So the only way that this would work is that because you would have to show me that this program would allow her to put it just in her name. And it's the same program, that's one thing. But to require for her to get a second mortgage to make a second payment, because she would, unless you have one wherein it's going to also have the effect of doing the same thing. Because if she's going to have a note, that's not the same thing.
Can you give me 1 second to find this document and present it on the screen? It'll be like 1 minute. Okay.
And also, Mr. Knowles, too, you got to also be mindful that if I'm doing this mathematical gymnastics in my head, the 62,000, because I've already indicated you're going to pay 50,000. I mean, you're already going to pay 50% of this COVID money, and it's coming out of your net. If your position is 62,000, that means the court is going to pull 31,000 out of your net, and then she would basically refinance the other 31. So
100%.
Okay, so your position is that's what she should be doing, refinancing this last 31.
Yes. 100%.
Okay.
That's it. Yes. Like to remove my name completely from all aspects of the marital residence. Like if
Okay.
she
What was the appraised value?
The appraised value, the appraisal that I got was $550, and the one that she got was $545.
Okay. All right. Are you presenting or showing me how you can refinance this balloon note?
Yeah, I'm downloading the partial claim subordinate checklist.
Huh?
I'm downloading the partial claim subordinate checklist by the servicer, and then also pulling up the note in regards to the claim. I have to log into their portal.
Okay.
Yeah. So it's just taking me a couple minutes. I'm sorry for the wait.
Okay.
Your Honor, I can move on to the other aspects of the contempt unrelated to the house.
Okay. Yeah. Okay. Yeah. Sure. I thought this was the biggie, but sure.
Biggie because it's time sensitive, but the others are part of our petition as well.
Okay. So, but let's give him so that he can participate and listen when you go through the other matters. We're going to take a 5-minute break, and that'll give him a chance to pull those other issues and send them, Ms. Marshall, so I can take a look at them. This concept being new to the court. Ms. Sterling, Ms. Austin, if you'll come to my office.
Sometime later.
I apologize.
Okay. All right. Now we can go ahead and proceed, Ms. Panic, with the other portions. You're on mute, and I don't see Ms. Knowles.
Thank you, Judge. I said my most brilliant things right then. Okay, Ms. Knowles, you're still under oath. Okay, we're going to continue your testimony. In the
Hey guys, welcome back to my channel. Today I made this wig. It's so cute.
What's that?
But
no.
Sorry, I think I clicked on something in the background.
Oh, okay.
Okay. Was Mr. Knowles ordered to pay $901 in child support each month beginning on 2023 as part of the temporary order, which was substituted for 810 in the final judgment?
Yes.
Oh, I'm sorry. Okay. Did he, and he was ordered to pay $901 in the final judgment, is that correct?
Yes.
Okay. And has he made those payments as ordered?
No.
Okay, I'm going to show you, Ms. Newble, if you could put up Exhibit E. Okay. Does this spreadsheet accurately reflect what Mr. Knowles paid and what Mr. Knowles didn't pay in terms of child support that he owed?
Yes.
Okay. Did I prepare this and show it to you to make sure it was accurate?
Yes.
Okay. Is it accurate?
Yes.
Your Honor, I move petitioner's Exhibit E in for identification.
He so admitted.
Okay. Now, Chelsea, did Mr. Knowles, in October, November, December, he owed $810 because of the temporary order. Is that correct?
Yes.
And he only paid payments of $967 and $300 during those 3 months. Is that correct?
Yes.
And then for January, February, and March, and April and June, did he make any child support payments in the amount of $901?
No.
Okay. Did he pay $2,500 as a lump sum in May?
Yes.
Okay. So the total he owed versus minus the payments he made leave $4,069 owed to you in child support. Is that correct?
Yes.
Okay. Are you asking for the court to find Mr. Knowles in contempt for failing to pay the payments as ordered?
Yes.
Okay. Mr. Knowles also was ordered to pay $3,963.52 within 10 days following the entry for unpaid school fees. Is that correct?
Yes.
Has he made any payment on that?
No.
And Mr. Knowles was also ordered to pay 40% of all fees related to the minor child's tuition And at the time of the final judgment, that amount was $5,725. Is that correct?
Yes.
And since then, for the next school year, has Mr. Knowles made any payments as ordered towards the child's tuition?
No.
And is that amount already due?
Yes.
Okay, Ms. Newble, if you could please pull up Exhibit G. Okay, so Your Honor, I'm going to move petition. Is this in a spreadsheet that I prepared with your assistance?
Yes.
Okay. Your Honor, I move petitioner's Exhibit G into evidence
Okay. Any objections? So admitted.
Let's go to the middle part of that. School fees owed for the final judgment was $3,963.52. Do you see that?
Yes.
Okay, plus the $5,725 he owed at the time of the final judgment, correct?
Yes.
And since then, what are the current fees he owes for Wynn's school?
$6,498.
Okay, and those have been unpaid, is that correct?
Yes.
Okay. The attorney's fees that he was ordered to pay in the amount of $18,649.48. Did he ever pay those?
No.
Okay. And he owes you 50% of Wynn's medical bills in the amount of $148.53.
Yes.
He's failed to pay that as well.
Yes.
Did you ask him to pay it?
Yes.
Did Mr. Knowles at any point take the child out of the state without letting you know he was going out of state?
Yes.
And what happened?
Unfortunately, one of Jeremy's close family members passed away, and Jeremy let me know, and he told me there were 2 services available. He did mention that one would be held in Atlanta, the other would be held in New York. He specifically said that he planned on attending the Atlanta ceremony because it was going to be similar to his late grandmother's ceremony that was also held here in Atlanta several years ago, and that he didn't see the need to travel with Wynn to New York.
Then what happened?
He ended up going anyway, and I didn't find out until he had traveled about 48 to 72 hours later, and where he dropped me a pin, just a random pin with a location that was unknown. He didn't tell me when he was traveling. He didn't tell me who he was traveling with, nor where they would be staying. And then I only found out because I was FaceTiming with Wynn, and I asked her what she was doing and where she was, and she just seemed really confused. It's almost like someone was coaching her on what to say. And then I asked him where they were, and then that's when he dropped the pin.
Okay. And did you immediately say, why are you in New York?
Yes. And he's like, I told you what was happening. I told you I was taking her, and that's not the case.
Okay. Did you have a chance to review the correspondence with him before that to make sure you didn't miss something?
Yes.
Okay. And did you miss anything?
No.
And he verbally told you he was going to the Atlanta one and never told you he was going to the one in New York. Is that correct?
Yes. And even invited me to pay my respects at the Atlanta one.
Okay. Did he ask you to prepare Wynn for anything?
No.
Okay. When you were starting the assumption process, you needed clearance for you to be able to contact the mortgage company. Is that right?
That's right.
And did he provide that to you as ordered?
No.
Jeremy was also ordered to obtain life insurance in the amount of $500,000. Is that correct?
Yes.
And has he provided you with any documentation?
No. And I have asked him about it, and we did briefly discuss me potentially. I know he said it would be a financial burden for him. So I did ask him if it was possible that he would allow me to take out a policy with Wynn being the beneficiary, and he agreed. to do like a living, forget what it's called, like a living insurance policy where the living beneficiary could take out, like say he was diagnosed with like a terminally illness or a disease, then the person diagnosed could potentially take out a portion of the policy, but we have not been able to come together on an agreement with that. Obviously, there's a lot of.
So you agree, you asked him if you could pay for the $500,000 insurance policy with Wynn as a beneficiary.
A different policy, not the one that he was ordered to get. I wanted to get my own policy in addition to that one.
Oh, okay.
Yeah, he was ordered to, by the final judgment, to get his own just for Wynn, but I wanted to take out one with me and Wynn as the beneficiary. And that's the only one that I offered, but he still needs to get, his own $500,000 policy that was ordered by the court.
Okay. I want to show you G again. Okay. You had the appraisal done, which came back at $545,000. Is that correct?
Yes.
Okay. And Jeremy said he had his own mortgage done, and that was for the appraisal was $550,000. Is that correct?
That's correct. Yes.
Did he provide you with the entire appraisal when you asked him for it?
No.
Okay. Did he say why he wasn't going to give you the entire appraisal?
No, he told me he was only going to give me what I needed or what he thought was appropriate.
Okay. The principal mortgage balance as of October 1st, which was the date it was supposed to be calculated by, was $302,130.46.
Yes.
And because of the order, it was to deduct 50% of the COVID relief payment of $25,000. Is that correct?
Yes.
You had to pay $3,013.50 for the cost of the assumption.
Yes.
And you had to pay $1,000 for the cost of the appraisal. Is that right?
Yes.
Which would bring the net equity down to $213,856.04. Correct?
Yes.
And 50% of that would be $106,928.
Yes.
Jeremy was also ordered to provide 50% of the repairs that he had made, which were wrong, into the marital home of $20,044.38, right?
Yes.
So the equity for the final judgment would be after reducing all of the things that were required by the court, it would be $86,883.64, correct?
Yes, correct.
Okay. And then did you and Jeremy enter into a discussion to take the money owed because you weren't getting it out of his portion of the equity?
Correct.
Okay. And so then if you see the reductions by the amount that we've already discussed and the credit of $2,500 that he paid towards child support, that amount would be $47,978.64. Is that right?
That's correct.
And then minus, again, the medical bills. So the total due to Jeremy so far would be $47,830.12.
That's correct.
And you were prepared to make arrangements to have that paid after you had the home.
That's correct.
Now, did Jeremy mention anything about a balloon payment as the reason he wasn't going to the closing? Or did he just say that you weren't going to pay him his equity on that day?
Correct.
Which one?
He told me he wanted to have his equity paid at closing, and that's why he did not show up.
Okay. And
he did not mention.
You had emails to that effect. Is that correct?
That's correct.
Rachel, if you could please pull up, starting with Exhibit N as in Nancy. Okay, so your closing was going to be April 26th, right?
Yes.
Okay, and that was a day before the 120 days.
Yes.
Okay, so did you and Jeremy exchange emails on Monday, April 22nd, 2024 at 6:58 p.m.? I'm showing you what's been marked as Petitioner's Exhibit N for identification. Do you recognize it?
Yes.
Okay. Is that an email between both of you?
Yes.
Okay. If we can scroll down, please. Jeremy, in this email, a little higher up, please. Thank you. Jeremy told you what the challenges he had regarding any of the closing. Is that right?
Yes.
Did he mention a balloon payment or a second mortgage in any of these in this email?
No.
And in fact, he was trying to get you to sell the house or him to sell the house on May 1st. Is that right?
Yes, I got multiple threats sent to me about him selling or entertaining cash offers because I was coming up on the 120-day deadline.
Okay. And just to back up a little, when did you first start asking Jeremy to help cooperate with the assumption process?
I first started back in October of 2023, but while we were waiting on the final judgment, they closed out the file because they needed the final judgment and divorce decree to start the assumption process. So once that was closed, I did reopen the case for the assumption in January. And I still had to call multiple times to get authorization to even speak. I had to have Jeremy on three-way to allow me to speak on behalf of the assumption. And I had to get him to sign paperwork to allow me as a third-party authorized person to start the assumption process. So that required us to meet. And we weren't able to meet until February due to scheduling conflicts and Jeremy's availability.
Okay, so it was about a month that it took just to get the process restarted because you couldn't get Jeremy's signature?
Yes. And then when I opened the process, he kept saying he hadn't received the welcome package. I called the mortgage company literally every single day and they would tell me, oh, it's been sent. But Jeremy had all of his mail forwarded to his new address. And I asked them, well, can you send it directly to me? They said no, because you're not on the mortgage. So it was just this huge loophole of me calling Mr. Cooper, calling Jeremy, telling them I haven't received the paperwork. Jeremy saying he hasn't received the paperwork. And finally, we were able to get the process started when Jeremy scanned the documents over to me. I ended up just using the old documents that Jeremy scanned back in October.
Okay. How far did that put you behind in the assumption process?
Several weeks.
Okay. And once you started the assumption process, how long were you told they normally take?
5 months.
Okay. So at the beginning of this, you knew you were going to be right up to the edge of the 120 days, right?
I did. And that's when I reached out to you all.
Okay. So, Your Honor, I move Exhibit N into evidence, if it hasn't already been.
So admitted.
Thank you. Okay. Can we move to Exhibit O? Okay. Is this the day before closing?
Yes.
Okay. I'm sorry. I'm showing you this for identification. What is it?
This is the closing documents that Jeremy required me to send him prior to showing up for closing.
Okay. And did you show them to him?
I did.
And in fact, acknowledged this the day before closing and sent it to somebody KW for legal review. Is that right?
Yes.
Okay. Your Honor, I move Exhibit O into evidence.
So admitted.
If we can go to P. Okay, so this is still, I'm sorry, I'm showing you what's been marked as Petitioner's Exhibit P for identification. Do you recognize it?
Yes.
Is it an email between you and Jeremy?
Yes.
Okay. I mean, there are other people on this, but you and Jeremy are communicating on this. Is that correct?
That's correct.
Okay. So tell me what this email is about.
So this email is about Jeremy not cooperating with the assumption process. We went back and forth about equity. Ryan Holmes from Keller Williams had been involved, who never responded to any of the email correspondence. So I'm not really sure what his part was in the process. I had Mr. Cooper involved, and Jeremy's concern was about not showing up because he wanted to make sure that his equity was going to be paid. Basically, he wanted to have a check hand delivered to him at closing, for him to show up to closing. But
Now, sorry, go ahead.
I was just going to say, we couldn't even agree on an amount to pay for equity. So it was just, we were just at a standstill. So that's when I forwarded this email over to you.
Now, today, you heard Jeremy answer the judge when he said that it had nothing to do with the not getting the equity on that day, but it was only about the balloon payment that he was concerned about. And that's why he wasn't showing up to closing. Is that right?
Yes.
Is that true based on what he was emailing you at the time?
No.
Okay. When's the first time he mentioned anything about a balloon payment to you? Was it after the closing had expired?
It was, yeah, it was definitely after.
Okay. Your Honor, I move petitioner's Exhibit P into evidence.
Be so admitted.
Okay. If you can go to Q, please.
Sorry, hang on one second. I apologize.
Okay. Showing you what's been marked as petitioner's Exhibit Q for identification. Do you recognize it?
Yes.
Okay. Is it an email between the two of you the day before closing?
Yes.
And what does it say? Well, Your Honor, I move petitioner's Q into evidence.
All right, so admitted.
What does it say, Chelsea?
This email is from Jeremy. He said, if you are not able to secure the monies to finalize the assumption and transfer of the deed, I would like to put the home on the market starting Monday so we can both move forward with our lives. Thank you, Jeremy.
Is there any mention of a balloon payment in here?
No.
Or a COVID relief payment?
No.
Okay. Just he wanted the money, the equity, because he thought it had to be paid on that day. Is that right?
Yes.
Okay. Even though he told the judge today that's not what that he understood that it couldn't be paid that day.
Yes.
Okay. If you could go
Let
to
me ask you a question with regard to since you're assuming and there is funds that you have to pay him, what was your plan? What was happening to ensure that you would be able to pay the payout? What were you doing?
So we got to a point, Judge, where Jeremy and I talked and we were like, if we could get to a number, I was prepared. And I even had to show Mr. Cooper that I had money available to pay Jeremy at closing. I had to show that I had funds available using my 401k to show that I actually had the money for closing. And I told Jeremy that, and he still didn't show up. I was fully prepared to pay him his equity based off of the calculator that we just presented that showed all the things that would be deducted that were ordered by the
But outside of those deductions, were you able to pay it?
Yes.
So even if you didn't make those deductions, you would have been able to pay him this, what was that? 80 something thousand?
Yes, I was prepared to take out money from my savings to pay him.
Okay. All right.
and certainly had, well, excuse me, we'll move on. Can you put up T, please? I'm showing you what's been marked as petitioner's Exhibit T for identification. Do you recognize it?
Yes.
Okay. is it an email between you and Jeremy, or you, Jeremy, and Victoria from my office on April 30th?
Yes.
Okay, and this is after Jeremy didn't show up at closing.
Yes.
Okay, what does this email say?
Hi, Victoria. Just following up on my email from yesterday. I just got off the phone with Chelsea and she let me know you have the calculations prepared for the equity payout. If we were to use the appraisal Chelsea got on Friday, minus the court fees, child support, etc., she let me know that the payout is around $16,500. Please send these numbers over so we can begin the process of closing. Underline in bold, I agree to have all fees subtracted from my portion of the equity.
Okay, so let's discuss what that means. We had also filed a 9/15/14 motion for attorney's fees. Is that correct? As a result of the trial.
Yes.
And that amount was in about $28,000 that we were asking for. Is that right?
Yes.
For Jeremy to get down to that 16.5, did he include that 28,000 as owed to you?
Yes.
Okay. So as far as you were concerned, had he showed up at the closing, you could have written him a check for $16,500.
Absolutely, and I let him know that.
Okay. Now, Your Honor, I move petitioner's T into evidence.
I'm sorry,
I move petitioner's T into evidence.
still admitted.
After the missed closing, did Jeremy send the code violation crew out to your house?
Yes.
Can you explain what that was about?
It caught me by surprise myself. So I actually had to call the officer that was listed on the notice. And the officer stated that I had an outlet moved from my living room and I was in code violation. And I let the officer know that wasn't true and that I'm being harassed by my ex, who I am about to go to court with over the ownership of the house. And I explained that to him. He said he knows how messy divorces are. He said we still need to come by and take pictures and just make sure that everything is up to code. And he said, let me know when you're available for me to come by. And that was the end of that. I didn't get any fines. I didn't get any citations, anything like that.
Do you know who called code enforcement?
Jeremy.
Okay. Did you discuss it with Jeremy?
No.
Did you have to retain us again, or never stop retaining us? Did you have to employ us for purposes of handling the closing and the contempt and the 9/15/14 from the previous litigation?
Yes.
Okay. If you, Ms. Newell, if you could pull up Exhibit X. Okay, I'm showing you the first page of Exhibit X. Do you recognize it, Chelsea?
Yes.
What is
Yes.
it?
This is a ledger of attorney's fees that I incurred from going back and forth with Jeremy about closing and just trying to get everything finalized so we can move on. But there was a lot of back and forth, and Victoria and Esther had to jump in quite a few times to try to get this resolved.
Okay, and Ms. Newell, if you can scroll down to the end. Okay. Now, to be clear, this was done after the 9/15/14 motion had already been filed. This did not include any of the things from the trial litigation. Is that right?
Correct.
Okay, this is just to handle the contempt and the motion for emergency hearing. Is that right? And preparing for today.
Correct.
Okay. What is the grand total that you have spent between the petition for contempt and the motion for emergency hearing and preparing for a trial?
$9,561.21.
Okay. Your Honor, I move Exhibit X into evidence.
So admitted.
If you can move to Exhibit Y, Ms. Newell. Okay. So if, what is this?
So this is a equity payout calculator showing what would be due to Jeremy after closing
Okay.
or at closing if he ever signs the papers.
Okay. So if the court finds Jeremy in contempt for this action and assigns attorney's fees for it, are you asking that that be reduced from his equity?
Yes.
Okay. So the $9,000 you just mentioned, $9,561.21, that's broken down here. Do you see $6,032.46 for the contempt, $1,846.88 for the emergency hearing, and then hearing prep through, what's today? Friday, through Wednesday. Is that correct?
Correct.
And so without putting in yesterday's prep and today's hearing, if you reduce that from the 47,830.12 that was from the other spreadsheet, the total due to Jeremy would be $38,268.90.
Correct.
Okay. And he had previously said that you could resolve, or he would pay the 91514 fees that we had filed, but we hadn't litigated yet. Is that right?
Yes.
Those are $28,115.07.
That's correct.
And so what would you totally owe Jeremy as part of his equity if, once the house is assumed, once the mortgage is assumed?
$10,153.83.
All right. Is that what you're asking the court to enter as the amount of equity so there that's owed Jeremy at closing?
Yes.
Okay. Your Honor, I move Exhibit Y into evidence.
So admitted.
Your Honor, if I could just have one moment to make sure I hit everything. Are you asking the court order Jeremy to attend the closing and sign the documents necessary to permit the assumption to go through?
Yes.
Okay. I don't have any further questions for her. I do have an attorney's fees. I have to stand in my place, Judge.
All right, Mr. Knowles, you have any questions for Ms. Knowles?
Yes.
All right.
Before we get started, can I submit or can I share my screen?
Yes, you can share your screen, but make sure this is something you're showing related to her. If it's something that you want to present yourself, you'll have an opportunity to do that when you get ready to present your.
Okay, thank you. I just wanted to share this. During Mrs. Knowles' testimony, I went into Bank of America and pulled up the actual transfers that I made, payment by payment. So they were missing this 1020 payment.
They're missing what now?
They're missing the 1050 payment in their calculations.
It was on there.
Oh, okay. Can you stop sharing real quick and let me ask Miss Rachel to pull up that one, the other one, so we can see the difference real quick. Miss Rachel, so Miss Marshall, you have to switch real quick. Or do you have to? I think you can put both of them. Okay, as okay. Can you go to that? Okay, so the 1050 looks like arrears per final order. There's a 1050 there, but I'm not sure. Okay, those were arrears per the final order.
Judge, I can show
So
it.
that you didn't attach as due and owing.
No, we showed that it was paid on October 10th.
Okay, that was, so it was supposed to be paid on 12/29. The arrear says that's what he was supposed to pay, and these are all new and upcoming amounts, and that amount was what was an arrearage.
Correct.
Got it. Okay, makes sense. Okay, now go back to, thank you. You can stop sharing. Okay, you can ask questions related to that or proceed.
Yeah. So in total, the payments you've received for Mr. Knowles or myself since the final hearing have been closer to $4,200. Is that correct, Ms. Knowles?
We just showed you the amount on the last document, so do you want me to total them up for you?
No, that's fine. I have another question. Ms. Knowles, how many schools is Wynn currently enrolled in?
1.
How many schools have you paid a retainer to?
1. I've paid a deposit for a summer camp that she's in, and she has a spot that's being held at her primary school.
Okay. And how much combined are these both in total for the year? Because in my understanding, the second summer camp, as you put it, title is, can you say the title of the summer camp?
Brilliant and Kind Montessori.
Okay, so it's a Montessori school.
Mm-hmm.
And how much is it per month?
It's $14.25 per month.
Okay. And how much is her other Montessori school?
So her other Montessori school, Carlisle Montessori in Buckhead, as you and I both discussed, we have considered enrolling her full-time at Brilliant and Kind Montessori, given the summer program is successful and she likes it. And we have her full-time enrollment would start in August, once you and I make a decision. Right now, yes, I did have to pay a $13.25 deposit at Carlisle Montessori of Buckhead to hold her spot in case it doesn't work out at the summer camp program.
Did you just pay a deposit or did you pay 60% of the full year?
I've paid a deposit at Carlisle Montessori because you told the school that we were going to get back to them regarding your 40%. So we have not gotten back to the school regarding your 40%.
Okay. In total, if you were to add up the annual fees of both schools combined, it's around $21,000. Would that be incorrect?
Your Honor, I'm going to object. She said that she's only enrolled in one school.
I know, so I don't know what that question means. I'll let Ms. Knoll answer it to the extent she can.
Yeah, she's only enrolled right now at Carlisle Montessori. She's at Brilliant and Kind Montessori for summer camp. We have not enrolled her full-time at Brilliant and Kind Montessori, which you're aware of.
Okay. So, so she's not enrolled in Carlisle's Montessori at all?
Yes, she is. That's her full-time school where she's been going since she was 18 months.
So she is enrolled in two schools?
She's at summer camp at Brilliant and Kind, which I've already paid for, which you have contributed nothing to. And she has a placeholder where she's enrolled at Carlisle Montessori, where she's always gone to school. That's the only school she's ever gone to.
Okay. So were you notified of the assumption paperwork on October 23rd of
What do you
20
mean notified of the assumption paperwork?
that it had been received by me? Did I text you?
Honestly, I don't remember the exact date.
Okay. Can I share my screen again?
Yes.
Yeah, I'm asking the judge.
Oh, yeah, you did share.
All right, let me pull this up. Can you read this text message to us? Just the first line?
Your Honor, it hasn't been admitted.
I'm sorry?
It hasn't been admitted unless this is one of mine.
No, this does not look like anything I've seen from you. So, Mr. Knowles, ask her if she recognized it and if it's a correct, and if it's correct. And that's the only way it could be admitted.
This text message, and is it correct?
I do see the text message, but I don't see the date that was sent. And you never brought me the documents that night. You actually brought me the documents in November at her soccer game.
So if you, is it your position, is it true and correct? Like, can you see the information? Are you
True and correct.
That the court can review it?
Yeah.
Yes, this is a text message between me and Jeremy.
Okay. You need to leave it up now because I need to look at it. Okay, you bet. Okay, I'm sorry. I thought it was. Okay.
What's happening?
I'm just, I'm looking at it.
Oh, okay.
Okay, so what's the issue? What's the point on this one?
The point I'm making is that she's been fully involved throughout the assumption process.
Who's been involved?
Chelsea has been involved and
At what now?
Chelsea has been involved through the entire assumption process.
I get that. She's doing it. What do you,
Yeah.
I'm confused. What's the point of this?
The point, yeah, I guess that Chelsea has been involved, that I haven't delayed the process at all
Chelsea has been involved?
throughout the assumption process. For the full process.
What was the position that she wasn't involved? How could she not be involved?
She is saying that I never notified her of the balloon payment at the end,
What balloon payment?
the second mortgage on the house.
I know. Where is that in here? I don't see that. I'm unless I'm not reading it. I just see you said I got the assumption papers, and that's everything else is about a party.
Okay, yeah. So once I received the papers, once we signed the papers,
Okay.
had
Yeah.
full control over-
Is there something in this text message related to the COVID relief balloon?
There is not, no.
Okay, I just, that's what I'm trying to figure out. If there's some portions to it I can't see, because
Yeah.
the only thing I see is that you said you got the assumption papers in the mail, and how is your equity gonna be paid?
Mhm.
Okay, all right,
Okay.
thank you.
Um,
I'm gonna admit this, in.
okay,
So what number are you gonna call it?
Exhibit B.
Okay, exhibit B. All right.
Yeah.
So admit it.
And Chelsea, in the flurry of text and emails that we like have gone back and forth throughout this process, have you identified or put it in writing anywhere where you plan to pay out my equity? Like after the assumption process, like at closing, have you wrote that down anywhere? Or would you say it had just been a conversation between you and I?
Can you close out this document, since we don't need it for that question. Stop sharing.
Yeah, I'm looking.
We actually have submitted several of our email chains with the payment calculator, and we were never able to agree, Jeremy. You never said, when we went back and forth about the equity, you never said, I agree to this number. So how could I know what to write on the check to say, I confirm this is what's going to be paid to you? We never came to an agreement. We always went back and forth, like you just said, through the flurry of emails. We never came to an agreement on a number.
Okay, so we never agreed that I would pay the 19-15-24?
You said that it could be taken out of the equity. You never said.
Never agreed to that, from what you're saying.
No,
Correct.
you didn't agree to it. We just saw the email where you agreed to it that I just read in my testimony.
Okay, so we did agree on a payment or amount?
You never agreed to a number that you were willing to pay. No. Or that you were willing to accept. No, you didn't. You said that's why you didn't show up to equity. In your last email, you said, I forget exactly what you said, but it was about the equity. And you never agreed to the amount that we presented to you in the calculator. You never agreed to it. And you said that's the reason why you wouldn't show up.
Okay, and why didn't I agree to it?
I don't know. You never said.
So you can say that I didn't agree to the document in whole or the calculation you guys put forward.
I'm not sure what you were thinking.
No, I'm asking, do you say I agree to the whole document?
What document?
The calculations?
I don't know. Do you agree with what we just presented? The 10,000? Do you agree with that?
I do not agree with the documentation that we put forward, but I'm asking you.
Mhm.
You said that I didn't agree, but we came to an agreement?
The agreement we came to was when you stated in the email that we just showed the judge, you said that I agree that child support, tuition, medical payments, and attorney's fees could be taken out of the equity. That's all you agreed to.
Yeah, okay. And we established equity through an appraisal, correct?
Yes.
Okay, so it was just the equity in the home minus the outstanding fees that I agreed to, correct?
No, in your last email, you said child support, you said tuition, you said attorney's fees. You said all those things in the email we just showed.
Okay, so I did agree to a number.
The $10,000? Is that the number you're stating? Which number? I know it's been so many
I'm
numbers.
asking, did I agree to a number?
Jeremy, you didn't agree to any numbers. That's why we're here.
Okay, and can you show me somewhere in writing that you agreed to pay me through your retirement account, through taking out a loan against the property? Do you have anything showing that?
So if the concern is that you wanted to be paid equity at closing, we actually have to, like I told you before, we have to close on the property for me to pay equity. I can't pay equity for a property that I don't own. I told you I was fully capable and able to do that. Like the means of those funds are frankly my business, and I presented that documentation to the loan company. But no, I didn't send you statements of my bank account to show you that I had the money. No, I didn't.
I'm not asking for that. Did you show me any evidence that you were going to pay me?
Jeremy, you and I talked multiple times, and I told you I was prepared to pay you.
Okay. Is your name on the deed and title of the home?
Yes,
So when you say you don't own the home, what do you mean by that exactly?
I don't own the mortgage.
Okay, do you have to own the mortgage to own the home?
Your Honor, I object for relevance.
Yeah, next question.
Okay. Do you currently own the home?
Objection, Your Honor.
Go to the next question.
Is your name on the deed and title?
Objection asked and answered.
I don't even understand the need for that, Mr. Knowles. I mean, what point are you making on the
Have
contempt?
you,
You know she didn't close on the home. And so why are you asking? You know she did not close on the home. How can you possibly ask her those questions? That's ridiculous. Go to something else. You know she didn't close on it. So therefore, notes are going to be in your name. Everything's going to be in your name. Why are you asking her that?
okay, can I show another thing?
Sure.
With documents?
Just make sure it's relevant. I don't have time for you to ask questions that you know the answer to and that everybody else in here also knows the answer to, because it's the very reason we're here.
Okay.
Hold on for one quick second. You can proceed.
Okay. Ms. Knowles, can you identify what's on the screen right now?
Your Honor, I'm going to object. It's exactly what the court just told him.
Okay, is this the document that was presented at closing? So if it is, and she recognizes it to be the same, he can answer. She can proceed. He can proceed.
Yes, it's a quitclaim deed.
Okay. Whose name is on the deed of the house? The two parties that are identified as the grantors?
Jeremy Knowles and Chelsea Denise Knowles.
Okay, and who are we collectively selling the property to?
Well, if you scroll up, it says a transfer of property from through a divorce or something. Can you scroll up a little bit?
Can you answer my question first?
I am in.
What is the question? What's the question?
Is next to grantee? Who are we selling?
I can't hear you.
Who are we selling the property to, Chelsea?
We're not selling the property.
Okay. But your name is on the deed. Okay.
Yes, this is the transfer. What's the question related to it?
Okay.
What's the question related to this deed? What's the issue with this deed that I'm looking at it for?
Nothing is wrong with the deed. The reason I'm showing this is to show that Chelsea owns the property.
You all signed this deed.
No. Well, she owns the property when we bought the house. Her name was on the deed initially, deed and title. Only my name is on the mortgage. But
Okay. I see what you're saying. You're saying that at some point you put Chelsea on the deed?
Yes. When we bought the house initially. She's always been on the deed and title.
Okay. For some reason, I thought you guys bought this house before you got married.
We did before we got married, but I always put her name. I put her name on the deed and title at closing when we bought the house.
Oh, okay. I see what you're saying. All right. So, okay. All right. Go ahead.
Yeah. So who is the grant?
So where's the original deed that you have her name on?
I don't have the original deed in my possession. This is the closing documentation that shows who was on the deed and who's only going to be on the deed.
Okay. Okay.
Can I admit this as evidence?
Yes. What number?
Exhibit J.
Okay.
Okay. Chelsea, did you ever inquire about taking out a second loan on the mortgage or on the house? Sorry.
No, because I don't own the mortgage, so I can't take out a second mortgage.
Do you need to own the mortgage to take out a second mortgage, or do you need to own the house to take out a second mortgage?
So my understanding is, since I don't have a lien holder, like how can I take out a second mortgage when I don't have a first mortgage? You own the first mortgage.
Yeah, okay. So correct me if I'm wrong, but you take out a mortgage on a property because that's what they can, I guess, that's the physical asset versus you don't take a mortgage out on a mortgage.
Okay, listen, I can't go through the idea of you all trying to educate each other on legal issues dealing with this document. I don't. So you can ask her, Chelsea, were you aware, or at least it is my understanding, that you could have taken out a second. Why didn't you do that? And then she'll say, I can't. And then you'll move on. Because
all right.
Idea that you guys are trying to jump through legal issues, to me, it's painstaking. I just can't take it.
Yeah. Okay. So Chelsea, were you able to take out a second mortgage on the property?
I'm
No,
going to object to relevance. She didn't need a second mortgage on the property.
I'm gonna let him finish. Okay, go ahead.
That's it.
All right.
The next point about the taking the win out of state. without notification. Did I call you to tell you that Marquise died?
Actually, you just sent me a picture of like a notification of a funeral, and then
Yeah.
I called you and
Yeah.
asked you what happened and expressed my condolences.
Okay.
And who was it that died? Maurice, who is that?
Marquise, that's my first cousin.
First cousin, okay.
Okay. And does here, let me show you this. Okay, I know it's small, but does this document have the address of the funeral?
I can't see it, but yeah, I can't. Yeah, I can't see it, but I do remember you telling me that there were 2 funeral locations in Atlanta and New York.
Okay, and was it my weekend for the first funeral, or was it your weekend?
For the first funeral, honestly, I don't remember.
Okay. Did I can remind you, it was my weekend. Did I offer
For the Atlanta funeral or the New York funeral?
New York funeral?
Okay.
Yeah. Did I offer to switch weekends since it made you uncomfortable that we would be traveling on such short notice?
We never even talked about you going to the New York funeral. You just told me that there were 2 services. One was in New York, one was in Atlanta. And you said you were going to do the Atlanta one for convenience and because it was going to be like the same place where your grandmother was buried.
Okay. And you said that I sent you a drop pin 48 hours after, or 48 or 72 hours after I got there?
Will you repeat the question?
You send a drop pin 48, or I send a drop pin 48 to 72 hours after I got to the funeral?
Well, I don't know where you were at. All I know is just I got a drop pin like 1 or 2 days after you were traveling. Like, I
Okay.
don't even know I don't remember when you said you went. I just know, I think you sent it to me like on a Sunday. I don't remember exactly like when the funeral was. I just know it wasn't the day of the funeral. I was just very confused and out of the loop. And I had no idea that you were leaving and taking Wynn with you to New York. No idea.
All right. So and I'm just going to replay a timeline. So you drop Wynn off to school Friday morning. I pick her up Friday afternoon. And she's back in school for Monday morning. So the whole weekend itself is less than 48 hours, from start to finish is 2 days. So we left Georgia or Atlanta late Friday night. We arrived the day of the funeral. You FaceTime Wynn. I sent you a drop in, also emailed you the flight itinerary, and then we flew back on Sunday morning. So we were in New York less than 48 hours, and she was back in school on Monday morning.
Like, my issue was you never told me what the plan was. Per the order, you're supposed to say where you're going, if you're taking her out of state, and who you're traveling with. None of that happened. You're saying you sent me a flight itinerary. Do you have a copy of that? Because I never got it. All I got was a random drop pin in New York. And then I'm FaceTiming Wynn, and she's confused, and you're telling her to say certain things on the phone. It was just a very weird situation. All you had to do was communicate to me.
All right.
As I would do for you.
So you FaceTime Wynn the morning of the funeral.
Mr. Knowles, can
Yes.
you, I can't, it doesn't even matter. Can you, the order says to let her know. Do you have the text message or whatever it is that shows you did that? That's all we need.
Okay, so yeah, I notified her of the funeral via the text message. She called me. We talked on the phone. I asked her to do Wednesday or nice. I also offered to exchange weekends because it was in short notice. Yes, so all of that.
All right. Is there any text message wherein you tell her that you are taking Wynn on this vacation or even evidence of the flight itinerary that you said you sent to her? How'd you send it, text or email?
Sent it directly from the Delta portal.
What now?
I sent it directly from the Delta portal.
The
When I
Delta
booked the
portal?
flights, portal. When I booked the flights, I include her email address.
Oh, okay.
Yeah,
I never got it.
yeah. So essentially, I'm just showing that we talked about the funeral. She was aware, the location. It was short notice, rushed. I informed her to the best of my ability
Okay.
from the beginning to the end.
Okay.
In regards to the code enforcement, I guess I would just talk to you, Judge, instead of asking her questions. It's not really.
Okay. Because if you don't have any questions, then you can bring these things up for yourself.
Okay, yeah. Then no more questions then.
All right. Thank you. Do you have any follow-up questions, Ms. Panich? You're on mute.
Sorry, Judge. I don't have any further questions for my client. I would like to request a 5-minute comfort break.
Okay. Right now?
Yes, please. I didn't
Okay.
want
That's fine. Did you send did you send that exhibit list to the court? Your exhibit list, Ms. Panich?
I don't know if we sent the list. We sent the exhibits, but I
Yeah,
can send the
that's
list.
fine.
I can
You
send the
sent it.
list.
No, I just wanted I wanted to during this comfort break go back over those exhibits. Miss Marshall would have them. Miss Marshall, did you forward those to me? And if you would forward those to me, thank you.
Yes, ma'am.
Your Honor, would you like the actual list?
No, I don't need the list. I just wanted to see the documents. Thank you.
Okay.
We'll take a 5-minute.
A few minutes later.
All right, let's go ahead and get started. We need to be wrapping up because I have a lunch meeting at 12:30 and I have another hearing in person that I start at 1:30. So I don't want to push this off any longer than necessary. So let's move quickly. I mean, we have the bolts and nuts of everything right now anyway. All right. What was you said, Ms. Kennedy, you had one more question to ask Ms. Knowles?
No.
Oh, no. Okay. Mr. Knowles, this is your opportunity to present to me any evidence that you have contrary to the position that Ms. Knowles has taken. All right. Unmute yourself. And I think I swore everybody in at the same time. Did I?
No. You just swore in my.
Raise your right. Do you solemnly swear affirm the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you may proceed.
All right. So we're here for 2 reasons: contempt for non-payment and contempt for not going to closing to sign over the assumption. First, contempt for non-payment. At the final hearing, Judge, I was represented by counsel, Bradley Weidman, and Bradley mixed our file with one of their other clients' file and submitted the wrong information to the court at closing. I'm going to share my screen to
At
show.
closing, what do you mean?
Or
Yeah,
sorry.
we're not doing that. You don't even have to bother. I'm not gonna listen to you redo my closing. My documents are what my documents are. It is what it is. So
Yeah, I'm not. The reason I'm showing this is assuming that I had $41,000 to pay out the
yeah,
court.
I'm not doing that. I'm
Okay.
not going back to reconsider anything that I've already made a decision on.
I'm just for the willful contempt for non-payment. I didn't have any money. I've been unemployed since June of last year, so a total of about a year. I've not been able to bring in the income at the levels that the court made the assumption that I could bring in. So the money I have paid to Chelsea has been more than 50% of the money I've brought in. So I've been doing DoorDash and random handyman work, but have earned less than $10,000 since the final hearing, but paid Chelsea $41,000 or 40% of that. If I, had the means to contribute more, I would. And I'm hoping that
Stop sharing.
Oh, sorry.
Unless you have a document that's coming here.
I'm hoping that changes soon in the future. Yeah. Also, with the home assumption process, she owns the home just as much as I do. The only thing she doesn't own is the mortgage. The judge, you gave her opportunity 120 days to assume or refinance. She doesn't need me at all to refinance the home.
Mr. Skip, go to something else. That's ridiculous. Move to something else. Okay. First of all, you need to be at that closing. Okay. Move to something else.
Yes. I need to be at the closing for her to
Go on to something else. You have to help in this process. And whatever is required of you, if anyone sent you anything and told you to come or do something that's necessary for her, you need to do it. And stop second guessing and having all of these other random thoughts as to what you should and should not be doing. Follow the order. If the order say participate and sign, participate and sign. You're going to have these random thoughts, these random flashes of, I know what I'm doing. And all it's doing is, Miss Panich, how much do you charge per hour?
I think Ms. Knowles pays $393.75.
So all it does is $393 an hour every time that you don't get it right. That's what you're doing. $393 an hour. So you got to start wondering if these ideas that you're coming up, are they worth $393 an hour? Because that's essentially what's happening here. You have these random issues, these random thoughts about how things are supposed to be, and they don't make sense to anybody but you. And the problem is that I feel sorry for you, Mr. Knowles, because they're making sense to only you. And you're paying attorney's fees on top of attorney's fees, and your money that you had are just dwindling, and you're the only person that can see what you're doing makes sense. And I feel sorry for you because every time you come back here, it costs you $3,000 and $4,000. But for some reason, it doesn't stop you from coming back here with some random ideas of why you're right. With these random thoughts, oh, her clothing is in an AC. When you know her clothing not in the AC, you know her clothes are outside, and you don't mind paying $393 to prove somehow that there's an AC in that shed when you know there's not. So $393 an hour just to show that her clothes are not are not outside, when all the pictures show they're outside. And you would literally come back to court with that. You gotta start thinking smart about the decisions that you're making, because you're going to be paying $393 an hour every time it doesn't make sense. You need to have a best friend or somebody to run these thoughts by. Because the idea, you know that if you take Wynn to New York and you don't have a ticket that you sent to her, You know what's going to happen. $3.93 an hour. So why do you put yourself in that situation? She has an attorney, Miss Panich, and she's good. $3.93 an hour. That's what you need. So when you make a decision, you need to figure out, is it worth $3.93 an hour? And you need to run it by somebody, because the decision you're making, whoever you're talking to, stop talking to them, because they're not giving you good advice. And I just honestly, I really do. I feel sorry for you. Because it just doesn't make any sense, the stuff that you're doing. Show me, Mr. Knowles, in this position that you're taking. Here's what I want to see. If you say you did not go to the closing because that you were concerned about the balloon note, show me where you said it in your text message or your emails, because you know well enough that that's what's going to be necessary. Your phone conversation with Miss Chelsea is not worth a hill of beans, and we all know that, because I don't know what she said to you. You need proof. How do you know you need proof? Because you've been in the middle of litigation for years now. You know you need proof. Do you have that? That's what I want to see. That you told her I want some evidence that you told her that you were taking the wind out of the state. I want some evidence that you told her you were concerned about the assumption, and here's the reason why. I want some evidence of that. I want some evidence of the fact that you have not found a job, and here's all the resumes that you sent out, and here's a list of all the places you've been. I want some evidence of that. Otherwise, you're going to be in a tight spot. So use these next 20 minutes that you have to give me some evidence, okay?
All right. Thank you.
All right.
Yeah, because I'm not obviously completely sure what is going to help the case or not, but that you made it very clear with that point. So I'll start with the evidence that I've been looking for work. And let me show you this. So I've applied, like just one of them, Deloitte. For what we do, we're compensation consultants. So I've applied for Deloitte. I've also applied for this thing called the BTG. It's the Business Talent Consulting Group, where you can actually get assigned to projects within companies. I've also applied to AVL Growth Partners. I've also applied for a Cobb County Innovation Grant, starting a company called Aaron that specifically uses AI to help with compensation. I've done Uber Eats, done random handyman work for the year. This is, so I applied to BTG under the business name Aaron. So I don't.
Let me see the Deloitte again. I didn't get the date on that one.
So this is just one of the jobs at Deloitte, but I applied to a few. So in our space, there's three main companies. There's Willis Towers Watson, the company I used to work for, Aon, the company that Chelsea works for, and Mercer is the third company. I've also applied for jobs at Mercer. So I've applied to multiple jobs that are equivalent to what I was earning before, to make the child support payments that are required of me by the court. Here's the flight receipt. So I went in the portal to try and get the email, but the email, since it was sent directly out the portal, but you can also see that, we flew out on January 19th, and we flew back in January 24th first. So we were there, for a day. She had a whole day of school on Friday. And we flew out Friday night to make it to the funeral on Saturday morning. And through the text messages, like she called me when I sent this across, and this shows the dates of both the funeral in Georgia and New York, and the drop-in location that I shared with her when we actually got to New York, where we are at. Now, with regards to the assumption process, like you can see that it's no question that I agreed to the money being taken out of the house. I received the balloon payment notification the day, or maybe 2 days before closing for Chelsea. So I sent those over to Miss Marshall, just to show the process from HUD and what they require.
Did you send or indicate to Ms. Knowles or Ms. Panich or any of the closing people the concern that you have prior to the closing?
No, no, I did not.
So then I just don't understand, Mr. Knowles.
I didn't get the notification about the balloon payment until the closing, we received the closing documents. That's when all the balloon payment stuff came back to me, like with the other documentation. So I wasn't aware that it was an issue until it was an issue 2 days before closing.
And did you let anyone know that that was the issue?
Yes, I did. Well, not that particular aspect, but I also, was willing to extend the deadline given by the court so we can figure this out before.
Okay, show me where that is.
Okay.
Your Honor, only because I know you're on a time crunch. I have those emails, except it doesn't say, it says the opposite of what he's
Can you
saying.
give him the date so he can pull it up? If you know.
Sure,
when
it starts March 7th, and then there's a string, and it continues through the 11th.
Okay, is that what you're talking about, Mr. Knowles?
No, I'm talking about this email in particular.
Okay, all right, go ahead.
Yeah. But if you read the last paragraph.
Talking about the PS?
No, sorry, I'm going to highlight this.
I have repeatedly requested.
Yeah.
Okay, I have repeatedly requested.
What's the date on that? Okay.
April 26th.
That's the day of the closing.
Yeah.
Okay,
I remain open to discussing extensions further. Consider this message, acknowledgement of your receipt of the email they sent me. Like, I've been open to resolving this. If you're unable to refinance in the time allocated by the judge, what's
the date of that email? I mean, what's the exhibit number on that email?
This is Exhibit L, avoiding litigation.
This is
okay. Mm-hmm. Okay.
Yeah. Then the L2, offering a quick sale of the property. If you're unable to refinance in the time allocated by the judge, I actually need a quick sale to ensure you get your money due ASAP. That's Exhibit L2. So please see attached. We also need to make sure we follow the process to remove my name from the balloon payment. I sent him the link. I asked him to mention specific areas in the home that were unrelated to the appraisal. But anyway, this is talking about the balloon payment, sending a link to the process to remove my name. And this is the date of the appraisal. So she got the appraisal the same day as the closing. Your Honor,
you said something about she was supposed to get an appraisal and you're supposed to get an appraisal. And what's the process as to which number you use?
The second number, my appraisal.
Why do you use your appraisal?
In the order, that's what it says.
And what was your appraisal?
450.
450?
Oh, sorry, 550.
Judge, I think they were supposed to average it, not.
I was going to say, it sounds like I would say average it, but okay, I'll look at it. So.
But yeah, she got the appraisal the day of closing. Your Honor, you gave me 10 days to get a second appraisal. So.
I see what you're saying. She got the appraisal the day of closing. Okay. Yeah. That's fine. And then yours is 10 days afterwards. That's still fine. I mean, we can still use the numbers because
they're very close to each other.
We can still rectify that. Okay.
Yeah, and this is what I got.
So I'll look. Do you know the paragraph where it says I'll use the higher appraisal?
Well, I don't think you even said the higher appraisal. You just said the second appraisal from my reading of the order.
Oh, okay. Yeah. Do you know what provision are you looking at for that?
Here, let me pull up the order. So petitioner shall have 120 days to assume a refund to mortgage and to pay petitioner 50%. Yeah, I think it's this line if I'm reading it right. He may suggest that the
May
parties,
request that the parties agree on an appraiser within 10 days of the rejection, and that appraisal should be used. So basically, it's not your independent appraisal, it's the appraisal that you all agree upon within 10 days of the rejection. And I think that was done with the concept that generally they would give you the appraisal prior to the closing. But to the extent that didn't happen, I can do some cleanup language there. That's fine.
Judge, I wanted to just chime in on this part too. If you scroll up a little bit, it says respondent shall have 120 days to assume or refinance the mortgage and to pay the petitioner. So long as wait. It says, okay, the value of the residence shall be based on the appraisal submitted by the finance company used by respondent to assume or refinance the loan. So as a part of the assumption process, an appraisal was not required. And I have emails from Madison.
Yeah, I get that. Yeah, I get that.
That's why I did it the day of, because Jeremy tried to use that as a barrier, saying, well, you don't even have an appraisal, so I'm not showing up without an appraisal. I said, okay, I paid $1,000 and had somebody come do it the same day. Okay, I'm like, okay, now what? Are you going to show up now? So it was
all right. Yeah, and I get that. There's there's just a little cleanup language with regard to the difference between what happens in an assumption and what happens in the refinance. It caused some issues with regard to that. But the appraisal was somebody you guys had to agree on if there was going to be an objection. So if Jeremy objected to the appraisal, then you all would agree on another appraiser within 10 days. And that is generally, like I said, with the understanding of the refinance, normally that happens significantly in advance and you have a little bit more time. But this time you didn't. And and you just got to make decisions, Mr. Knowles, because you might say right now, okay, I want to do this. You get another appraiser and the value is lower. So, I mean, you're talking about $445, $450. You guys should be able to just say, split the difference between it and move on. Because you're going to spend more time, more energy fighting over what is ultimately going to be $2,500 each of you than it might be. So, but I'll let you guys, I'll finagle the language to make, for clarification purposes with regard to these contingencies that the court did not consider. But ultimately, you're a $5,000 fight. I know $5,000 $5,000, but when you think about what it takes to get there, sometimes just meeting each other halfway is better than not. But okay, go ahead.
Your Honor, just to be clear, there is an email that Mr. Knowles said we can use her appraiser because he refused to give us the entire appraisal. He cherry picked portions of it. And then when we said, just send it to us, he wouldn't. So we said, okay, well, then he sent me something. And I said, well, at this point, I don't know what you're sending me. Just have the appraiser send it directly and copy you. And then he just responded with saying, just use yours, meaning just use her number.
All right. Go ahead.
Yeah,
all right.
I'll elaborate on that. So Chelsea reached out to the appraiser to send it to her directly. And Esther reached out to me to have the appraiser sent to her directly. And I said, okay. So I asked the appraiser to email Esther. He didn't want to get involved. So, and they want to move forward with the calculation. So I said, just use yours. It's not that big of a deal. It's $2,500. Like in the grand scheme of things, just so we can get it done.
But Jeremy, why wouldn't you just send us the appraisal? I sent you the full copy right when we got it. We didn't understand what was the issue.
Okay, Ms. Knowles. No, go ahead, Ms. Knowles.
So I asked the appraiser also to take photos of the, separately before I did the appraisal, to take photos of the kitchen. And I had code enforcement go out to the property to look at the work that was done. Then, because when I was going back and preparing for this, I saw the invoice of a GFCI outlet, two of them, for $22,000. And I found the equivalent outlet on Amazon for $11. So I just what is the difference of $21,000 in these, in the cost of these two things? So having the code enforcement go out to see what was actually done, and he did confirm that an electoral outlet was changed for $22,000. And that was I think that was the big back and forth. And just coming, I know the court already ruled on what was paid out, or what's supposed to be paid out, or what is to be paid out based on certain calculations. I just want to understand what was actually done.
Okay. All right. Any other issues?
No other issues.
All right. I'm at a point where I have to I'm at a point where I have to leave. It can't. I just don't understand. I really do. I hate that we're even here off of issues that clearly you all should have been able to resolve. I mean, literally, you should have been able to resolve these issues. I don't get it. So I find Mr. Knowles in contempt of court. In contempt of court, Mr. Knowles, for failing to pay the child support that you're supposed to pay. I find it disingenuous that a week before your hearing, you then apply for these jobs. You got one job you applied for in January. All the rest of them that you presented to the court, you just applied for in May. I think, I don't know what's going on. And honestly, I don't think it's beyond you not to get a job during this time frame to be hurtful. I don't think it's beyond you. Just like you're calling a code enforcement on her for outlets. I think that's you guys are, I think that's petty. I think that's completely petty for that to happen. So it's not, I don't think it's beyond you to do it. And so I find you contemptible for taking the child out of the state with no information like you're supposed to. I find you're in contempt of court for not paying the child's support, the tuition, and the medical fees, and also not providing life insurance that you're supposed to. With regard to the issue of the closing, I mean, I think you would have a valid point to be made if you had made a point with regard to trying to determine how this balloon payment was going to be resolved. But it appears that you were more concerned about how you were going to get paid with your equity. And quite frankly, that was not your concern. Your concern was to come to closing and get a check at the end of closing. And to the extent that you wanted to determine what that check was going to be, that's the negotiation between you and Ms. Knowles. Okay, just want to make sure. What check am I getting? What's the amount I'm supposed to be paid? Which really would have been what the value was of that house minus the $25,000. Everything else, the other decisions you all made, that's just gravy. If you decided to say, okay, hey, I know you're supposed to pay me $86,000, but because I owe you X amount, let's agree as to what amount you're going to give me. That it's okay. But was she supposed to be ready to pay you? And that's what I asked her. Was she ready to pay it? And she said, yes, was the value of the house minus the $25,000 because that's what's in my order. And then the other amounts that you're supposed to pay, those things you were supposed to pay, but you didn't necessarily have to pay them at the closing table. But she was supposed to be responsible for paying you the $86,000. And she said she was ready to pay that to you. So you should have been at closing. If you had gotten to closing and all of a sudden she says, I don't have any money, I can understand you going, wait, I'm not signing. But you got to come to closing and you didn't go. And you didn't go, and all of a sudden, all this balloon stuff comes up, and it becomes the basis of why you didn't come to closing. And all the other documentation that was presented does not suggest that that was the reason why you didn't come to closing. So I find you in contempt. I'm going to pay. I find that you'll pay the attorney's fees that Ms. Penich presented if she's able to stay in her place, the rationale for it. Which of course I'll give her an opportunity to do so, but she's indicated that she's presented at least through her witness how much money she's charged. She'll have to make a basis for that as well. To the extent she does, you'll be responsible for the attorney's fees as well. Now, here's the thing. I have given you an asset, which is, or I have made a final determination as to the fact that you're supposed to get the equity out of this house. I cannot specifically indicate that all of the fees and things that you have agreed that you are supposed to pay has to come out of that equity. I cannot specifically order that, but it appears that you have come to an agreement on that. I am, however, going to order, because of the contempt, that those things are paid at closing. Okay. So where you pay it from and how you get the money to pay it, that's up to you. But it is to be paid at closing. To the extent you all come to an agreement as to the set off and the write-offs and what that number is, that's fine. But you need to have your check at closing, which is the total of what you owe at closing. And to the extent that Ms. Knowles owes you funds at closing, you all can set that off, but that'll be your independent business. But for right now, to purge your contempt, you need to be ready to pay all those fees at closing. And I hope that distinction makes sense, Ms. Panich, as you write this up. Does it?
But only that Mr. Knowles will say he doesn't have the fee, so he's not coming to closing.
Well, he does. He will have the fees because we know Ms. Knowles has to pay him those fees. So he will have the money. That's how I know I can hold him in contempt, because the money is available. Now, what he does is up to him, but he needs to come to closing prepared.
Okay. I think I got it. Judge, also, there was a 9/15/14 that's ripe for decision because Mr. Knowles didn't respond. It was
I have to notice him for that, and I don't know if it got noticed. So that 9/15/14 has to be noticed. And I don't know if the notice said that. I think it was noticed as a status. I'm not sure. Ms. Marshall, how was this case noticed?
It did not include the attorney's fees, Your Honor,
Okay,
because it
so-
started out as an emergency, remember?
So I have to notice him for the 9/15/14. Mr. Knowles, so I thought he indicated that he was conceding the 9/15/14 motion. What's the position on that?
I do not concede.
Okay, so you're coming to court, which means that she's going to ask for this 9/15/14 motion, and then she's going to ask for attorney's fees on top of that. Okay, so,
All right.
But it will be noticed.
Your Honor, do you want me to state in my place or attach an affidavit?
You can stay in your place now, so we can just be done with this issue. You could just send
Okay.
everything one.
Your Honor, I do have a question. So
Give her a second to state in her place on these attorney's fees, and I'll take your question. Go ahead, Ms. Panich.
Your Honor, I stayed in my place. I'm an attorney sworn in Georgia since 2006, and in Florida since 1996. My hourly rate for Ms. Knowles, I believe, is normally $5.25 an hour, but she gets a 25% discount to $393.75 an hour. The hours that Ms. Knowles reflected and that are in my attorney's fee invoice are reasonable and necessary to handle the to deal with the contempt and the preparation for trial today. This would not include yesterday or today's, so I would ask the court to allow me to add those into the proposed order. But they're all reasonable and necessary, and I've been an attorney almost 30 years, so these aren't unusual fees.
All right. And also want to clarify also part of the order with regard to the balloon note. So Ms. Chelsea's position is that the balloon note can be assumed. Do you know the time frame for that? So we can put the assumption of that note in that time frame.
I'm just learning about this, so I don't know the time frame. I made
I'm
that
going to put 120 days for the assumption of the note.
Okay. Judge, I have a question for you as well. So now that we have a ruling, we'll have to wait for like the final order to be able to give the mortgage company. I'm just asking for, I guess, some time to, like, I don't know when we're going to actually have the order versus.
Okay, so Ms. Panich, I'll give you some grace with regard to the timing. So you have additional time to close. You'll have additional time to close.
Thank you.
Judge.
That's the issue I ran into last time.
Well, text me, Chelsea. I couldn't hear that.
Okay.
So she assumes the primary mortgage first and then assumes the secondary mortgage?
It's not a secondary mortgage. It's a balloon note. For
Okay.
which your position is it can be assumed. I don't know if it can be assumed. You said it
My
could.
position is it cannot be assumed.
Your Honor, that makes no sense. It's the same servicing company that's dealing with both mortgages or both debts.
Okay.
So in the case it cannot be assumed, what is the process?
Then it'll remain.
In my name?
Yes, because does that balloon note show on your credit report? 'Cause I don't
So,
think it does.
yeah, not for a credit card, but if I were to buy another home and try and qualify for an FHA mortgage, it would say that I owe $60,000.
Your Honor, if the court wants, I can get some information from Mr. Cooper and forward it to him.
Yeah, okay, that's fine. This is one of those I'm not quite certain about it. Yeah, let's figure it out with regard to the second piece.
So I sent Miss Marshall a bunch of documentation from HUD, not from Mr. Cooper.
I don't know what that means, sir. I mean, you sent us a list of stuff of different possibilities. I don't know what that means. I can't really do a lot with that because I don't understand what you're trying to say with regard to it. I assume that your position is that the matter should be, there should be a refinancing of that note, but that just doesn't make any sense to me because that's going to require her to make payments on that value now. And that's not how it's set up. So I don't want that to happen. So let's figure out what the possibilities are as to make this what the court envisioned, which is basically her taking it over or having one note, not for her having two notes. So that's kind of what the court envisioned. So it might be, I don't know if you can, I don't know, because it doesn't make sense to me to pay off that note at today's value. Like the whole point of it is to 30 years, you pay it off or you sell it, and then you get a value as to when you get ready to get rid of it instead of doing it now. But by the same token, I understand initially I was thinking, well, if it's a balloon note, and I'm looking at the point of it, it probably won't show on your report. It's probably not showing as a debt or credit, or debt against you. But your position is that it may not show, but if you got ready to get another house, it'll show that you have this debt. Is what you're saying, right?
Correct.
Right, and that's not necessarily fair to you as well. So yeah, Ms. Panich, can you look into it and see what the alternative might be?
Yes, Your Honor.
So,
and we'll hold all the timing until that issue is taken care of.
Okay,
all right.
thank you.
All right. All right, anything else? All right, y'all take care.